Okay, we're going to go ahead and get started. If everyone could please do a couple of things. One is Leslie's going to try to turn off people's cameras, but if you're not presenting, if you could turn off your camera, that would be great. Normally we like to do the exact opposite, but if you could turn your camera off, that would be great. And second, please, if you could go ahead and mute your line and try to stay muted as best as you can, that would also be helpful. So welcome today to our presentation. This is the fourth presentation that we've had in this series that really came about because, quite frankly, of the pandemic. And what many of us were seeing were clients that were coming to us with financial issues in a quantity in terms of the number of clients that we really hadn't seen before unless you really did a lot of bankruptcy and workout work, particularly as it relates to cancellation of indebtedness income. So we put together a 4-series program. The first was on COD, and it's available on the website. And we did this, by the way, jointly with the tax section and the business law section of the Florida Bar. The second is we talked about bankruptcy, and we focused on bankruptcy generally, as well as what I like to call the COVID or the pandemic rules, things that are particularly came up around the time of the pandemic. The third program was state and local issues. And the fourth is a program today where we're going to try to put it all together, and we're going to actually work through a fact pattern and a scenario and make it, we're kind of looking in and watching an actual client meeting, if you will. And who are the players? The first is Dan Fogarty, who in real life is a bankruptcy lawyer. So in this particular scenario, he's going to play the bankruptcy lawyer. The second is Matthew Brown, who in real life is a tax lawyer and once again is going to play the tax lawyer. And then we have Chris Callahan, who is going to play one spouse of the clients. And then we have Micah Fogarty. And by the way, both these people are good tax lawyers. And Micah is going to play the other spouse, the other client, if you will. And as you can see from their backgrounds, they're not even in the same location, which, is telling in and of itself. And I'm going to play the moderator. And since I do a bunch of controversy work and lecture on ethics, I'm going to periodically chime in and talk about those things. For those of you who love course numbers, the course number today is 4097. Again, the course number is 4097. And I want to do a quick plug for an upcoming tax section program. It's the Advanced Wealth Protection Seminar. It's Friday, October 23rd. And if you're trying to find it online to register, is course number 4283. But again, that's not the course number for today. It's the course number for the Advanced Wealth Protection Seminar that the tax section is putting on Friday, October 23rd, and it actually should be excellent. And I want to remind everybody again to please keep yourself muted. And if you could, go ahead and try to keep yourself off camera. And on that note, we are now going to look into a real live client meeting with Matthew as the tax lawyer and Dan as the bankruptcy lawyer, meeting with potential clients, Chris and Micah.
Well, welcome, Chris and Micah, to the law firm of Fogarty and Brown. My name is Matthew Brown. I'm a tax lawyer, and with me is Dan Fogarty, who is a bankruptcy lawyer. We understand that you met with a local accountant, Adam, and Adam gave you our name for some issues that you're going through right now. Before you came in, we checked and cleared any conflicts, and we sent you a list of some documents that we were hoping you could pull together. Understand that there was a pretty extensive list, and you might have had trouble getting that together today. That's okay. We'll try to refer to those throughout the discussion today. Before we get into that, if you could just give us maybe a little bit of background on what you're going through.
Yeah, sure. Thanks again for taking the time to meet with us. Really appreciate it. Basically, we have a family business. It's been in my family for a long time. It's a staple of the community. And things were really going well with it until COVID. And since COVID, it's been more difficult. We're reliant on takeout. Selling our food as takeout, which really doesn't fit well with our business model because of the quality of our food. And we've been trying to get by with the PPP funding, but it's starting to run out. So, recently our expenses, our payables have kind of gone up, and the bank, which was being a little bit lenient the past few months, is starting to come knocking and ask us for our payments. And frankly, we just don't have the money to pay. So we're starting to get a little nervous.
Yeah, and we've had to dig into our personal assets. We've had to pull some of the equity out of our personal residence. We've had to dip into the kids' college funds, and that's just to kind of maintain kind of current operations at the restaurant. So the more we dip into our personal assets, the more nervous I get, because I'm not sure that the restaurant will recover after COVID.
Yeah, I mean, I'm a little bit more bullish. I am hopeful that this family business that's been around so long would bounce back, but it's, you never know. I guess in a positive note, we do own the real estate underlying, underneath the building. So that's a positive, obviously. I think it has significant value, in a normal market. But we do have a mortgage on it. We definitely owe money to the bank regarding that land. And again, as I said before, we really don't have the cash flow right now to make those payments.
So, guys, thanks for coming in, at least virtually, and meeting with us. I think as Matt mentioned, there were certain documents that we were looking for. I think we gave you guys a checklist, kind of looking for, as current financial information as we could get. I understand you guys are having a hard time putting that together, so we'll just sort of work through that as best we can today. But let me tell you what I sort of understand from the broad overview of the facts that you gave us. We've got the restaurant and operations and the land that the restaurant operates from. And then we have your personal assets personally. So why don't you tell us, as we start the meeting, what your goal is?
I mean, my goal is to hang on to the restaurant, keep my family's legacy alive.
So my goal would be a little bit different. I married into this family. I'm at the retirement age, and as you can see, I'm currently in Aspen right now. This is where I envision spending my retirement. We've got children, they're at college age, so we've got college expenses to think about. So I don't envision spending, again, my retirement years, putting blood, sweat, tears, and money into a restaurant that is, failing.
And these times have been really difficult for lots of people like you guys, and we're here to help you guys try to get through this as best we can. I think, Chris, you mentioned that the restaurant was okay before COVID, but has taken a big hit since. Can you tell me a little bit more about sort of restaurant operations financially?
Yeah, I mean, historically, it's been a highly profitable restaurant. We're known for innovation, and actually, right before COVID hit, we were about to change the menu. We had this new item, BLT and A without the A, that was just gonna be an amazing seller. Obviously, I am bullish. I believe in this company. I believe in this restaurant. I think that once COVID's over and people can come back to my restaurant without concern, we're going to be in great shape. That's my feeling.
Yeah, I think my husband is more optimistic than I am. I think we were doing simply okay before COVID, but I've seen a downward trend over the last 20 years. The profit margins are getting slimmer and slimmer, where our personal expenses are getting larger and larger, with the approaching retirement and college age kids. So I don't see a bright future for the restaurant. There are a lot of new organic farm to table restaurants popping up on, it seems like each street corner. And I just don't think that we'll be able to revamp the restaurant enough to attract the customers that we really need to survive and also provide income for the lifestyle that we envision going forward.
So at this point, I'm talking to the audience. And, you know, we've had a little bit of an overview of the situation. You know, this is generally a meeting that will last a long time, that you will get sort of bombarded with a lot of information, maybe some of which you've gotten before, but a lot of it's coming to you in real time. So, you know, from a bankruptcy restructuring lawyer, you're asking a couple of questions, maybe now for the first time, but maybe you've done it as part of your sort of intake process. But you're trying to figure out who needs help. You've got two individuals in front of you, and they've made reference to, you know, at least two different companies that would have two different sets of assets and operations. So, you know, who am I trying to help? And is there a way to help everybody, or do I need to sort of triage and help one, maybe to the detriment of another? Where's the best relief that I can get for the people that I'm trying to help primarily? So is the bank is coming after them? There's probably other creditors that we'll hear about and need to think about. But are we talking about something that a bankruptcy filing would be the most effective route to take, whether that's for the corporations or the companies or the individuals? Is, you know, trying to get a resolution with clients or creditors individually? Is that the best route? Should we be looking at an assignment for the benefit of creditors under state law as a better way to resolve the business debts? Should we be looking at, you know, some combination of all of those? But, you know, are they eligible to file a small business case under the new Small Business Restructuring Act with the higher amount under the CARES Act? You know, we're trying to figure out. We've asked for the financials. We didn't get any. That's, I think, incredibly common, unfortunately. But is the restaurant going to be able to make it? You've got disparate views from the husband and the wife. We don't know whether, you know, who's right, who's wrong. We don't know whether they're the right people to make that call. So do we need to be thinking about getting them some kind of financial assistance that, you know, can guide them through the process? A financial advisor, somebody to help clean up financials, put together a set of projections, things like that. That's going to help the restructuring lawyer say, you know, is the restaurant able to be saved? Does it make sense to pump money into the restaurant for other purposes to try to help the individuals personally? Are they the problem? They don't know how to run their business. They don't know, you know, whether to run how the business is running and how to improve it. And then, you know, finally, you know, who am I talking to? I'm talking to, you know, two individuals that are, you know, probably fiduciaries of the companies that they own or operate. And so at some point, we all need to be cognizant of that their fiduciary duties to the companies might not just be what's in their best interest, but might be what's in the best interest of the company. We need to know what type of company it is, but might be in the best interest of creditors and might not be in their best interest, and they need to be mindful of those things. So back to the meeting. So Micah, maybe you can tell me a little bit more about the creditor situation specifically.
Yeah, my biggest concern is our tax debt, and the reason is the corporate debt has somehow transmuted into personal liability for us. I think it's payroll taxes. The restaurant did not pay payroll taxes. So there's a liability assessed against us individually, and we currently have a lien on our personal residence. So that is particularly concerning to me. About a year ago, we met with an estate planner who reorganized everything. You know, we have the restaurant operations, I think, in one entity, and we have the landowning entity that owns the restaurant land, another entity, and we have a huge organizational chart I thought the objective of that chart was to make sure that we are not personally liable for any of this debt. So I am concerned seeing this debt, which tax liability, which appears to be in our individual names. So I would say that's my primary concern in terms of the current creditors right now.
Yeah, I mean, that is very concerning. I agree with my wife. But again, I also am very concerned about just the company itself, the debt that the company owes and being able to pay that off or restructure it or whatever, so we can keep this restaurant going. That's my big concern.
Michael, unmute yourself.
So there's a few issues here that we really need to address, both from a procedure and from an ethics standpoint. The first of all is, who the heck is the client? There's likely to be a pile of entities, particularly if an estate planning attorney came and layered entities. We also have two spouses here who, on the one hand, their interests are aligned. They want to get on with their life. They want to have a nice retirement. But in many respects, they're not aligned. And you can see in this conversation, and it's very common, I run into in the procedure world where one spouse is flat out blaming the other spouse for the problems. So the question here is, do you close down the business and try to protect themselves personally? Do you take a go at running the business? And these are issues you got to discuss with the client, but you've got to be clear on who the client is or who the clients are. Second, is there a conflict? And do they understand what that conflict potentially is? The other thing that doesn't get talked a lot is we have an obligation as attorneys to tell clients things that are unpleasant. And we have to tell those things to the client, even if they could hurt the attorney. Typically, we see that in a situation where an attorney perhaps committed malpractice. There's a deadline coming up. The question is, should the attorney tell the client? And you have to give the client that unpleasant information that could hurt the attorney. Here, it's a little bit different because assuming that these clients can pay, the question is, if you really raise some of these issues, is it going to cause them to walk out the door? And you're really going to have to weigh that as part of your conversation. Procedurally, we're not going to deep dive into the tax controversy arena. But the second somebody starts telling you about tax liens filed in IRS and Department of Revenue nastygrams, you've got to immediately find out what the deadlines are. Because if you miss some of those deadlines, all you needed was somebody to come in 2 days before a deadline for filing a certain type of an appeal. And if they miss that deadline, they no longer have the ability to go to tax court tax court. You've just potentially bought yourself a grievance and or malpractice when you haven't even gotten into the issue, because it really wasn't the primary reason why they ended up in your office. So you've got to be able to address all of these issues.
Okay, so back to the meeting. So you mentioned, Micah, that you had a pretty complicated organizational chart. Do you know, do either of you know by chance what type of entity holds the restaurant?
Micah, it's Florida LLC, right?
Yeah, LLC.
Yeah.
Okay. Pause and address the audience now. So oftentimes clients are not going to be entirely aware of what type of entity they may have. And also there may be questions as to what the entity is for tax purposes, both federal and state. In this case, our client is literally out in outer space. So I would wonder, you got to be careful about any information he gives you. But an LLC, Florida LLC, that is going to be relevant for many reasons, and particularly to Dan and his bankruptcy considerations. But for tax purposes, an LLC can be any number of things under what are commonly referred to as the check the box regulations. If it's owned by a single person or a single member, it could be a disregarded entity, or it could be a C corporation or an S corporation. If it has more than one owner, it could be a partnership, an S corporation or a C corporation. So that's something that we're going to want to know, because it will affect many different things, including our cancellation of debt analysis to come. So let's go back to the meeting now. Do you, by any chance, know what kind of tax return the entity files, or if it even does file a tax return?
I think Adam might be able to tell you better, but I think it's an 1120S. I think there's a dash S at the end of it. I think, does that sound right, Micah?
Yeah, and I think I've seen a K1 in your individual name. So yeah, S and K1.
Okay.
Okay, so it sounds like, and we will assume for the rest of the meeting, that it is an S corporation and that at least Chris is a shareholder. But that's something that, again, we're going to want to run to ground.
So it's me again. And as we probably all learned, don't believe what your client has to tell you. And it's really an important thing. Sometimes the clients flat out lie. Oftentimes, however, they either tell you what you want to hear, kind of like telling the dentist that you floss every day. But sometimes what ends up happening is they don't really know, much as Matt pointed out, that they think it's something, but it's not, it's something else. Or people that walk in and call something a limited liability corporation that judges will do. And it's simply not. And it's really important that you actually get the facts. Personally, I will often ask the same question a couple of times, sometimes a couple of different ways, trying to get what's going on here. In addition, as we talked about before, the two spouses are not totally aligned in what they want to do. So is there something else we need to be digging into deeper? Is there something that perhaps Chris hasn't been telling Micah, as an example? So you've really got to try to dig in and find out what's really, really going on.
So Chris and Micah, why don't you, have you guys filed all of your personal returns, all of your business returns, sales tax returns?
I think so. Our prior accountant, he was supposed to handle everything for us. So we kind of just left it up to him. I don't know whether he did it or not. He kind of got a little bit unresponsive towards the end here. So that's where we ended up chatting with Adam, who gave us your guys' names. So I don't really know exactly what's been filed or whether it was filed timely, but at least I was paying someone to do that. I don't know. Micah, what do you think?
Yeah, I'm not sure that we have filed everything, or at least I don't know if we filed everything timely. We are getting a lot of IRS notices, and quite honestly, I'm overwhelmed. So I've just been kind of putting it to the side and letting it stack up. I have not read them, but yeah, we can't tell you if all returns have been filed.
Okay. Well, as I'm sure you're aware, not reading them doesn't make them go away. We're going to want you to bring any of those notices in. Assuming you retain us, we'll want to see all those notices and to help us get an understanding of what your current situation is. We can also reach out to your prior CPA to see if we can get copies of any notices that he or she might have. Another thing that's going to be useful here is we'll ask you to sign a form 2848, which is a power of attorney, both personally and for your business. That's going to give us the ability to reach out to the Internal Revenue Service and get what are called account transcripts and help us get a better understanding of exactly what the situation is so that we can better formulate a plan. And those transcripts are going to tell us, among other things, whether you have failure to file penalties, whether you're current, things like that. So we'll be better able to assess things later on once we get that additional information, but that's just something to keep in mind as sort of a next step.
So as Matt has described, those transcripts will let us know whether you've timely filed the taxes. And from a bankruptcy attorney perspective, those are going to be critical. You need to know, before you're filing a bankruptcy case, what type of tax claims you're going to be talking about. We've heard about liens. So we're trying to figure out whether we're talking about liens that would be against the company's assets, that would be secured claims, that would have to be treated in a bankruptcy case, basically paid the value of their collateral. We're trying to figure out whether we have priority claims, which would be sort of recent taxes, and again, entity specific or individual specific. Priority claims are, they're not secured claims, meaning they don't have any collateral to look to. There's not a lien or a levy that's been filed or been filed properly. But they are entitled to treatment ahead of other unsecured creditors, which would be sort of your customary trade claims and things like that. And then we're trying to figure out whether they would fall into that unsecured bucket, where in a bankruptcy case, you're sort of when you think of pennies on the dollar, that's who you're talking about. And again, from a are we looking at a workout, or are we looking at a bankruptcy? From that perspective, you sort of need to know whether you're going to be able to get out of bankruptcy if you file. And so you need to know what types of claims you're dealing with and whether you're going to be able to achieve a result based on what types of claims you have. So the analysis of that is absolutely critical. And I think the point about getting the transcripts is one that shouldn't be glossed over.
So first thing here is we clearly have the service, the Internal Revenue Service involved. My gut, as the fact patterns continue, will likely have the Department of Revenue. So a couple of things I want to point out here. First of all, and I say this regularly to clients, don't turn a civil matter criminal. Clients will have a tendency to want to push, and they're scared. And there's intra-family issues, and many times they have long-term employees and they're trying to protect them. Don't let them turn a matter criminal. Don't let them misrepresent going forward, which ties back to gathering the facts that we talked about before. One of the things you're likely to find here is that there may well be other people involved with the business that also may have liability. Do they have a general manager or somebody else who is signing checks, paying bills, and things like that? And sometimes the client will go back to them and say, no, we got this under control. And they'll even have you speak with them, but they don't quite realize who it is that you truly represent. Procedurally also, the Florida Department of Revenue can be, in many cases, far worse than the Internal Revenue Service. And you're likely to see cases turn criminal much, much faster at the state level than federally. In addition, it's really, really critical that clients stay current going forward. So even if they weren't collecting and remitting their sales tax previously, or they weren't withholding and then paying over their payroll taxes in the past, well, that's bad, but they don't want to continue to do that going forward because A, they can be shut down. B, if it wasn't criminal before or didn't have a lot of a criminal indicia before, now it more clearly does. And it's not like the clients can any longer say, I didn't know, I didn't understand. So you really, really need to be careful. The other piece of this, and it's really the first time we've talked about it, and it's the reason why all of us are on this program today, and that has to do with competency. You could be a really first-rate business workout lawyer or a bankruptcy lawyer or a tax lawyer, but it's very likely that you don't have knowledge and skills across all of those arenas. And even if you did, if the business decided to shut down, how many people on this call are familiar with the WARN Act as it relates to if you are laying off enough employees in certain locations? So you really need to make sure that you're competent. That's an ethical obligation that we often forget about because we're just trying to serve our clients. But be careful you're not going to bite off too much. And the other final note I want to point out at this little fourth wall break is all of these notices that they're sitting there with. Okay, it's really critical that even if they don't hire you, that you say something much like the personal injury lawyers do. That, for example, some of those notices may have deadlines. We haven't reviewed them. Those deadlines are strict. You need to review them. And if you're going to take it on, then you can't sit there and say, I'll look at those notices in a week. If you're taking them on as a client, you got to do it right away.
Yeah, and I think the point that Michael makes goes in part to prioritizing the solutions. Again, not to sort of harp on it, but there's a sort of a panoply of things that you could place these clients into from a restructuring path. But you want to make sure that you're not doing something now to solve a temporary problem by creating a larger problem. If you put somebody in a bankruptcy case and you haven't analyzed avoidance actions, for example, well, we've talked about the IRS as a creditor. Arguably, they've got you've handed them over to a trustee that has a 10-year look back period, and we haven't talked at all about what transfers have been made in the last 10 years when things were going great. But you can also use remedies on one level that sort of prioritize outcomes on another level. You talked about responsible person taxes. Could you file a case for the restaurant, try to get a plan confirmed, and try under the plan to have the payments that the company makes on those tax claims applied first to the employee share, thereby reducing the potential responsible person liability. That might be a reason to overpay to keep the restaurant open where it might not make sense otherwise. You're funding losses at the company level in order to protect the individuals. So getting back to the meeting again, Micah and Chris, let's talk a little bit more in depth about your creditors. Why don't you tell us who your top creditors are from your perspective?
Yeah, so we have been getting a lot of IRS notices, and I've seen the number roughly around $5 million on a bunch of them. So I think we owe the IRS a nice chunk of change. And then there's also a bank loan that's secured by the restaurant property. And that's also approximately $5 million. Those, I hope those are our two biggest.
Yeah, and the ones that are most concerning to me, throughout this process, my parents and my best friend loaned approximately $1 million to us. And I guess hearing you talk about this, I would think that those loans fall into the unsecured bucket. But those are the loans that are most concerning to me because it's, friends and family.
Yeah, so thank you for that. So let's just talk, and we talked a little bit about different types of tax claims, but who your creditors are in a lot of ways is going to drive the process that would be best for you guys. So we're going to want to look at the bank's loan documents. We're going to want to see whether there's a hole in the collateral that allows us to create some value that way. We're going to want to look at the tax liens that we've talked about and whether the relative priorities of the bank and the IRS and the timing of those, again, whether that's something that we can use to achieve a better outcome. For the company, if the company is going to file a bankruptcy, the goal is to get a plan confirmed. And so we need to know who the creditors are, because we need to think before we're filing, how is the company going to get out? So, generally under a plan, we're talking about paying secured creditors over time based on the value of their collateral. So we're going to need to understand what the collateral is, what the value is, whether there are reasons to overpay or underpay. And from an unsecured creditor standpoint, look, your friends and family are most likely not going to be able to be treated differently than other people. We know that you would feel differently about your friends and family and would want to pay them ahead of maybe other people. But that's that might not be possible in a bankruptcy case.
So you're saying that we can't do just a bankruptcy with the IRS and bank debt and just kind of leave the friends and family out. That's my preference. I want to leave the friends and family out. I don't want them to be paid pennies on the dollar. I want to repay them the entire $1 million, because this is really straining my relationship with my friend and parents.
So we get this a lot from people in your situation. I think I've heard a wise person say, don't turn a civil matter into a criminal matter. And so as part of a bankruptcy process, or really part of a, most, if not all, out of court processes, somebody is going to ask you to sign a set of schedules or a form or some disclosure, and it's going to ask you to do it under oath. And I haven't heard anything that we've talked about today that leads me to believe that there's any issues that we need to be concerned with about inaccurate disclosures in the past. But if you're going to do that now, you're going to create issues that are going to prevent me from being able to help you. And so this process, the bankruptcy process, depends on transparency. It depends on a full and broad disclosure. It's open kimono. And so, I need to make sure that you guys understand that before we get into this process. From a plan perspective, in a Chapter 11 case, for example, there's a lot of creativity in the process. And so, can we look at bringing your friends and family along as part of, giving them some equity in the company, if that's something that they would consider, that might give you some back-end creditor protection. In terms of the, you get a call a couple of years down the road from a friend and family after you've gotten your individual discharge, that's going to be a violation of the discharge injunction. And so we need to understand that if the only way to reaffirm a debt in a bankruptcy case is to go through a reaffirmation process. And so all of these things, I'm glad we're talking about them now. But I want to make sure that you're open and honest with me, and I'll be open and honest with you.
Okay, so if we want to save the restaurant and go through the bankruptcy process, what happens to us personally? And, I also want to know what happens to the friends and family loan.
So, I think unfortunately your friends and family are, again, depending on what the restaurant and entity looks like, are going to be behind a lot of other creditors. And so, obviously we've talked about the goal of filing is to get a discharge. Companies get that under a Chapter 11 plan. They don't get it otherwise. And so, if the goal is to get money to your friends and family, it might be difficult. But it's, I think from a Chapter 11 perspective, the only way to do that is going to be from a successful operation of the restaurant or a sale of the real estate. So we can talk about, does it make sense to try to sell the real estate? You can get doc stamp tax exemptions under Section 1146 of the Bankruptcy Code. That might be a way to prioritize things. But, so I think from the company standpoint, that's really the only way. We would not talk about a Chapter 7 for the company, at least not in this situation, almost no situations, but certainly not in this, because importantly, companies don't get, entities don't get a discharge in a Chapter 7. So we're, I think unfortunately, Micah, your friends and family will hopefully stay your friends and family, but getting them that big recovery just might not be in the cards.
Yeah, sorry, hon, but Look, and that's unfortunate to hear, but maybe we should have thought that through. But it does sound like you guys have laid out some good options here. I mean, it sounds like we have some different paths that we could take. A buddy of mine who had gone through a process like this had said there was some maybe tax implications of doing a bankruptcy, which didn't really make a lot of sense to me, given that I'm trying to get rid of debts, not add them. But is there some sort of income tax issue if I file bankruptcy?
Yeah, that's a great question, Chris. As far as the taxes go in this example or in the spec pattern, there really is no free lunch, unfortunately. So there's a concept under the federal income tax principles called cancellation of debt income, also known as COD income. It's an acronym that people use. In your case, there's a couple things that we want to think through. We asked you at the beginning to get an idea of what type of entity this was that held the restaurant. I mean, it's my understanding based on the facts we walked through today that the restaurant or the entity that owns the restaurant is the borrower under the debt here. So the debt from the bank, the $5 million, it sounds like the restaurant borrowed that. And the friends and family debt, it sounds like the restaurant may have borrowed that. But we'll talk through whether we think that's correct or not. If the restaurant is the borrower, cancellation of debt in the case of an S corporation is determined at the level of the S corporation. So what does that mean? That means that we ask ourselves, if the S corporation is able to retire or get rid of this debt for less than the amount owed on it, right? That difference is cancellation of debt income to the S corporation. So why do you care about that? Because you're a shareholder, and as a shareholder, you're liable for flow-through income from that S corporation, right? So cancellation of debt or COD income at the S corporation level could mean additional tax liability for you as a shareholder. Now, there is good news, though, that there's exceptions. There are many exceptions, actually, to cancellation of debt. And I think actually a good way to view it is that it's a general rule with many exceptions, right? And there's a whole code section devoted to the exceptions, section 108 of the Internal Revenue Code. And in the case of an S corporation, this may seem obvious to you, but it's not obvious to people who understand how S corporations work. The ability to qualify for the exceptions is determined at the level of the S corporation rather than at the shareholder level. So in this case, if the LLC files bankruptcy, if the S corporation files bankruptcy, there is a possible exception that could apply to cancellation of debt income for debt that is canceled as part of a bankruptcy. Okay? So to the extent the S corporation does realize cancellation of debt income, you may qualify for an exception. Which means that you don't have to pay tax on it now if you qualify. Something to keep in mind, again, going back to the no free lunch, is that section 108, to the extent you take advantage of it, requires you to adjust tax attributes. And the first one that we would typically look to in this case is ask ourselves if there are any suspended losses from your S corporation that you have not been able to take as shareholders yet because of you didn't have enough basis in the stock of the S corporation. Those suspended losses, you could have benefited from them in the future, but if you use the exclusion, you have to reduce or eliminate those losses. So you can view it as sort of a timing rule. You don't pay tax today, but you might pay tax later down the road. Okay, so it's a good, just keep in mind that it doesn't go away necessarily, but we can live another day. It's kind of a good way to view it. If you don't file bankruptcy and we do something different, like some type of debt workout or restructuring outside of a bankruptcy, a couple of things to think about. Well, actually in the bankruptcy too, is how are we going to calculate the cancellation of debt income? Dan brought up a good example of you might, convince the friends and family or be able to, as part of a plan, get the friends and family to take stock in exchange for their debt. If that were to happen, we would look at the difference between the amount owed and the fair market value of that stock at the time of the exchange. So, there's quite a few moving pieces and sort of complicated calculations that would come into play here. But outside of a bankruptcy, there's another exception. There are other exceptions, and the first one again and the general one we look to is the insolvency exception. Again, tested in this case at the S corporation level. We would look at whether the S corporation has more liabilities than it does fair market value in its assets. To the extent the liabilities are greater than the fair market value of its assets, it's considered insolvent for tax purposes. And that difference can also result in an exclusion from your current income for the cancellation of debt. Once again, it requires attributes to be adjusted. So just something to be aware of that, if we are able to come up with, Dan's going to come up with a great plan for you. We have to think through what are the tax consequences, and there are likely to be cancellation of debt tax, income tax consequences, but there are ways to mitigate your exposure to current taxes.
Got it. Well, it seems like you really like this COD income concept. So to the extent you guys figure this out without causing us more income tax, you can have as many codfish sandwiches at our restaurant for the rest of your lives free of charge. Okay.
Oh, well, that's very generous. Thank you.
Yes. Okay. Well, I'm not sure about that. I think I'd rather, spend whatever money we have on this vacation home in Aspen that I've been eyeing. But Matt, Mr. Brown, thank you for talking about the COD implications at the corporate level. But as I think about it, the loan from my parents and my friend, I think it was actually made to me personally and maybe not to the company. And in fact, I don't think that there's anything in paper documenting those loans. It's just kind of a, they love me and made a loan to me. Does that affect the analysis?
Yeah, it may, and that's not unusual. I'm not surprised to hear that necessarily. What we would need to do sort of as a first step with that loan is we want to figure out who the actual borrower is for tax purposes. Is it you or is it the business? If it's you, all those things I just talked about, those are going to apply to you as an individual. But sort of as a first step, actually, and this is a kind of an interesting point, with this being a friend or family loan, we'd also, want to ask ourselves, to the extent they go ahead and forgive it or write it off, you may actually have a gift for tax purposes, and which could result in, gift tax consequences to your friends and family. So that's kind of, keep that in the back of your mind as a sort of secondary principle. But at the individual level, if it does indeed produce cancellation of debt income, the same sort of exclusions could apply that we talked about for your S corporation, but they'll be tested at the individual level instead of the S corporation level. So just put in simple terms, if you aren't filing an individual bankruptcy, we don't have the bankruptcy exception on the table. And that would take us to, as a next step, looking at that insolvency exception. And again, that's testing liabilities against the fair market value of assets. We'd want to look into, basically what your personal financial picture looks like to get a better idea of that.
Fair enough. And I think we guaranteed personally some of this bank debt. The bank wouldn't give us the loans without us signing our names. If we file for bankruptcy, do we get out from underneath that debt as well? Is that covered here?
So that's, obviously a very common question. I think the loans these days without some sort of guarantee are few and far between. And so let's talk a little bit about the things that we need to think about. Maybe this meeting is running a little bit long, so maybe we'll discuss this in our next meeting. But the things we're going to need to look at, we've asked for the loan documents, so if you're able to put those together, that would be extremely helpful. But we need to see whether you both guaranteed it. Given your two situations, I think it's still a little bit unclear whether that might be the case. Whether you're both members, whether you're both operators, so we need to look at that. We need to look at whether, Micah might have, she might be a passive, non-owning, non-operating spouse. She might have different defenses, Chris, to a guarantee than you might have. So you mentioned that you guys have put up the house. Most of the times in a bankruptcy case, you're not really able to restructure in any meaningful way debt secured by your primary residence. One of the new amendments to the Small Business Reorganization Act actually would allow you to do that if it's used for business purposes, the underlying loan. And so, when somebody pledges a mortgage on their house in order to secure financing that is either for the business or supportive of the business, that provision sort of recognizes the reality and allows you to, would allow us to maybe do that. So that's something to look at. I think we've talked a lot about discharge provisions, and normally that is only going to apply to the person that files. The automatic stay applies to the person that files, but in certain circumstances, and I think, Chris is the operator of the restaurant, and, if you guys are willing to put in more money, make a post-petition loan to the company, we might be able to get an injunction, that would be temporary, but would allow you guys not to have to deal with any suits on the guarantees while we focus on trying to work out relationship with the bank. Again, reason for picking one restructuring option over another. Really what we need to be aware of and maybe thinking through is, again, we're trying to figure out what the best remedy is. And so, if we're the right people, and Chapter 11 for the company is the right thing, we're going to need to get you guys separate counsel, both because we need to be disinterested. We can't represent the company in a bankruptcy case and guarantors, generally except under rare circumstances. But I think it'll make sense for you guys to get separate counsel, for any number of reasons. And they'll be able to give you, advice that's directed to both, or maybe just one of you specifically. So, that's sort of a broad brush how we might deal with guarantees as part of this. But Matt, do you want to talk about the tax implications of those guarantees?
Sure, and we're coming up on lunch, so I'll get back to your COD income, Chris, the COD. So we talked about the COD income or cancellation of debt income on the business's debt, and maybe you have personal debt. Guarantees, typically, if you're relieved of your obligation under a guarantee, as a general matter, it's not going to create cancellation of debt income for you personally. There's tax court case law on that. But we would have sort of a first principles question in a case like this of, is it really a guarantee or is it debt for tax purposes? And there is, seminal case law on that point in the Fifth Circuit, from prior to the date when we had an 11th Circuit, which that's where you're sitting in case you're wondering. One's in outer space and one's in Aspen, I guess. So maybe not necessarily, but that's where most taxpayers in Florida would be sitting. Called plantation patterns. And that case basically stands for the principle that, if the S corporation in your case really wouldn't have been able to take out this debt if it wasn't for the guarantee, if the loan was effectively made to you, in that case, for tax purposes, we're going to treat it as your debt, or that's the position the IRS might take. So we'd want to think through that as far as, thinking through a filing position for any future workout or bankruptcy that you have here and any relief you get on this debt. And thinking through your filing position, we'll want to, make sure that we, belt and suspenders, get comfortable that this is in fact a guarantee at the personal level and debt at the S corporation level, and not the other way around. Another point with respect to guarantees to keep in mind, Micah, we talked about how the insolvency exception could apply to you at the individual level. And if you did otherwise have cancellation of debt income from this friend and family loan. Important to think about there is the guarantee on the business debt, this $5 million bank loan, may be treated as a liability for purposes of that insolvency test. And it's a pretty large loan. So, that could be helpful, at least in that respect, to help, maybe defer the impact of any cancellation of debt income at the individual level. And basically that's going to turn on whether, we can get to a position that it's more probable than not that you'll be called on as guarantors to pay. And there's, again, case law on that subject. So, just a couple things to keep in mind with respect to that guarantee.
Thanks.
Wow, this is really confusing, and there seems like there are a lot of moving parts to this.
Yeah, this is pretty crazy.
There's certainly a lot of moving parts to these cases. And even in this situation, we've gone for not quite an hour, and you could see how we've barely scratched the surface just to try to really understand what the facts are. There's a few things really want to just reiterate here, more from the ethics and even procedure point of view. These cases are complicated, and while you're delving into it, you really need to be careful of some of the ethics issues. First of all, pretty clearly after this meeting, you're going to want to write some sort of a CYA letter. And it may be the engagement letter. It may be a, hey, let us know if you want to hire us letter. It may be a letter saying we haven't been retained. But with the information that they gave us, clearly we know that they may well be facing certain deadlines. So even if you don't know what those are, you really ought to advise the clients of that. A couple other things. It's not uncommon in these types of cases for somebody else to be coming up with fees. And remember, there's an ethical obligation that if somebody else is paying the attorney's fees, it's got to be with that client's consent, which kind of goes back to who the client is here. And I do want to remind everybody that if the attorney does get some sort of a credit at the restaurant for cod sandwiches, that is income to the attorney. We talked about competency briefly before, but that also can go to scope of representation. It is permissible for attorneys to limit the scope of representation as long as they can still competently represent the client and that scope is limited. But the client, much like with any waiver, needs to understand what it is that they're limiting or what it is that they're waiving as it relates to conflicts of interest. And my kind of rule of thumb is if it takes me more than a page to explain it, maybe there really shouldn't be a conflict waiver in that kind of a situation. Remember also that it's not uncommon in these situations for you to actually be working for the entity as well as for the individual. If there's other owners of that entity and the primary owner, the one that you might consider your client, wants to sign a waiver for the conflict between the individual and the entity, that's often not the best choice. You're generally going to want to get the other people involved with that entity to sign that waiver. Otherwise, you sort of create an internal conflict within the entity itself. So be very, very careful. A couple other things real quickly. One has to do with privilege. And people often conflate the idea of privilege and confidentiality. Confidentiality is our ethical duty to keep our mouth shut. Privilege is an evidence rule. And you've got to remember that the CPA client privilege is much more limited than the attorney-client privilege. So you have a situation where you may find yourself, as tax lawyers like to call it, hiring the CPA to assist the lawyer, at least initially, with what we often call a Covell letter. And you might want to find out what the CPA and others actually already know. The other challenge here is there's so many people that start to get involved in these cases. While you may have a duty as a lawyer to be confidential, keep things confidential, if too many people perhaps involved in the business, for example, Chris goes back and starts telling his general manager everything that was talked about, that privilege can really be lost. So you need to be very, very careful there. And finally, under Circular 230, the rules governing proxy for the IRS, all conflicts are waivable after disclosure. But under virtually every bar rule that I'm aware of at a state level, all conflicts are clearly not waivable. So you need to be very, very careful knowing what your role is and kind of keeping that issue, in mind. So finally, I want to remind everybody that the course code is 4213. There is some materials in the chat. And Leslie also, when she sent you out the materials or the Zoom link, there were some other materials in there, some of the cases and statutes and whatnot, and a bankruptcy checklist. These were sent out. They were talked a little about in the program. And on that note, we thank you very much.